Hello everybody and welcome to this free webinar on the breathing space regulations with David Smith. David Smith did a talk for us quite a few months ago. It was earlier this year, wasn't it, David?
Yeah, I went and dug up my slides, and it was certainly it was way back when we were all unable to leave our houses, and everyone was battening down the hatches.
We had this new case come along, and I thought it'd be a really good opportunity to get David back again and to bring us up to date with what's been happening. Now, this is going to be a fairly short webinar, but we may have time for a few questions. So if you're listening to the recording, obviously, but if you're here live, if you can put questions in the chat, we'll answer them if we can. Anyway, take it away, David.
Yeah, cool. Thank you. Just as a starter, just a quick reminder of the breathing space regs. So we're talking about the debt respite breathing space regulations passed back in November in 2020, came into effect from the 4th of May this year, and they apply to all debts, whether incurred before or after the 4th of May, with sort of limited exceptions. Mainly things like council tax debts and stuff like that, and court judgments and things like that are exempted. But basically allows a registered debt advisor to create a breathing space, which means that the debt can't be pursued in any way, and all legal proceedings based on that debt must stop, and that includes rent arrears possession. So, for example, you wouldn't be allowed to issue a Section 8 notice in respect of a debt that fell within a breathing space, and any existing possession proceedings would have to stop in respect of that breathing space. There was also the mental health breathing space, which is actually more about what we're going to talk about today for specific reasons, but some of what I'm going to say applies to all of them. So mental health breathing space allows mental health professionals to ask a debt advisor to create a mental health breathing space, which again protects people from rent arrears, but only for very, very severe mental health crises, where basically someone has been hospitalized or is being relatively sort of considered for hospitalization. Which is a relatively short-term event, but the mental health breathing space is open-ended. It goes on as long as the person is considered to be in severe mental health need. So it's obviously a concern to some people that these things could go on forever and ever, though in practice it doesn't tend to work that way. Now, the key point about this is that breathing spaces have to be reviewed. Normally, a standard breathing space is 60 days and it has to be reviewed after 30. But you can also ask for them to be reviewed. So you can ask the debt advisor to stop them if they're unfair. If the debt advisor says no, you can apply to the court and to make it come to an end. And of course, it only restricts proceedings based on a debt subject to a moratorium. So it's only the debts that are the subject to the breathing space moratorium that are restricted. So there's no, well, I mean, this was actually part of the issue. There was a question mark over proceedings based on new debts, but there is no restriction on proceedings based on new debts that are incurred during the moratorium, or Section 21 claims or ASB claims within tenancies. It doesn't affect those because it's only about debt. Okay, so it's that's a sort of summary of where we are. Now, the reason that we want to talk about this is there was a High Court decision really recently in a case called Ax Nolo versus Brake, and it is the first substantive decision from a court, and from the High Court no less, so therefore binding on most lower courts, on breathing space on the breathing spaces. And in this case, it was a mental health breathing space, although some of the comments made are applicable across the board to all breathing spaces. So it's quite useful and interesting in that regard. So that's the sort of purpose behind this webinar, really. Now, I'm not going to dwell on the Ax Nolo and Brake legislation, but if you want some entertaining reading, you can go and read about it. This is a massive and long-running case, which entertains the legal sector anyway. And it's been to the Court of Appeal, I think, 3 separate times. The judge has been asked to recuse himself twice. It just goes on and on and on, this case. It never ends. And it's mostly to do with a mortgage repossession, to be precise. But then there's various cross accusations by the defendants, the breaks, about fraud and all kinds of things, and it just goes on and on. Occasionally, you get mortgage repos that go like this, and it's one of the sort of entertaining aspects for lawyers, I suppose. And it's also quite good for our fees, obviously, so we're quite happy about it. Now, what's interesting about this is literally 2 days after the mental health breathing space regs came into effect, one of the breaks sought a mental health breathing space. And he's committed to care in a mental health institution. And a mental health breathing space was applied for on his behalf and granted, I hasten to add, literally on the 6th of May, 2 days after all the stuff came into effect. Which of course then created a moratorium in respect of the debts. And of course it applied across the board because it applied to all his debts and to his joint debtors. And the claimants were seeking to have that breathing space set aside. The reason that this was a big deal for them is that basically the breaks are losing to have lost quite a lot of the litigation so far, and they owe a lot of money, both in respect of the original claim, but also in court fees. So they're now down for several £100,000 of court fees, and the claimants wanted their court fees, basically, not to put too fine a point in it. And they were somewhat aggrieved by the idea that the breaks could simply escape the consequences of the litigation they were running, and potentially continue to run litigation without having to pay the consequences of it not going well and having to pay the other side's legal costs. That's the sort of primary beef about the whole thing. So the claimants had asked the debt advisor to set the thing aside. The debt advisor refused. They then applied to the High Court to do so. So a number of different things came out of this. The first question that was actually asked was this the right court at all? So the breathing space regulations say that you set aside by application to the county court, not the High Court. However, the regulations don't say exclusively the county court. They just say application should be made to the county court. So there are some regulations where the only place to make an application is the county court, but these were non-exclusive. So the High Court said, yes, you can make an application in the High Court, but only if there's a good reason. And in this case, all of the litigation is in the High Court. So it was perfectly reasonable within the context of the existing litigation to make an application in the High Court to have this set aside. But what the High Court did say is the county court is the normal spot, and you shouldn't normally apply to other courts unless there's a sound reason to do so. This case was exceptional. So that was the first sort of interesting point. The next bit was about how to apply. So this got a bit involved, and actually the High Court got itself in a bit of a knot about this and got it wrong. So the application was actually made by a straight application notice called an N244 application notice, for those of you who are in the know, supported by witness evidence. The High Court initially said that wasn't correct, although they let it go on this case because it was the first one. They said, oh no, it needs to be an originating claim, so a new fresh claim in the court. But actually, they were wrong about that, and indeed, there's a postscript to the judgment where the judge says, oops, yeah, I did get this wrong, and I'm amending my judgment so that I don't mislead people in future, because there's actually a court rule on it and a practice direction on it to show that the correct way to do it is by application. What is interesting and worth noting is you don't just make an application. These applications had witness statements with them, and indeed there were witness statements in response. And I'll come back to that, but you need more than a mere application saying this isn't fair. It needs to be supported by substantive evidence. And the evidence actually ended up becoming a bit of a discussion topic in this case. So the regulations set out the terms of when you could have these set aside. And the two criteria are: it unfairly prejudices the interests of the creditor, or there has been some material irregularity. The starting point is to ask the debt advice provider to cancel it, then make an application to the court. Now, unfortunately, the guidance doesn't really canvass this well. It gives some examples of situations that might be material irregularity or unfair prejudice, but there's only one example for unfair prejudice and several for material irregularity. So there's not a lot of helpful material in the guidance. But actually, there was quite a lot of extensive policy discussion that took place before these regulations came into effect. There were policy papers produced by the Treasury and other parties and consultations. And so the court held that it was open to it to consider all of those. And in part, it did so. So the overall context of the regulations are important. Now, in this case, the main thing being relied on was unfair prejudice. So as I've alluded to, the beef that the claimants had is that they were already owed a couple of £100,000 in legal costs. And they said it was ridiculously unfair that the Brakes could carry on with litigation when they weren't required to pay the consequences of their already failed litigation and pay the legal costs that were owed to them. And they were saying they should be prevented from carrying on with the litigation at all unless they paid up, or this thing should be released and they could be forced to pay up. Now, this was made even more interesting because the Brakes were taking the view and were trying to argue the point that debt moratoria didn't just apply to aged debts, i.e. debts before the moratoria came into effect, but applied to any new debt incurred during the moratorium as well. So that sort of annoyed the claimants even more because they were then going to be in a position where they could carry on with litigation, keep losing, but never, or at least for the time being, they wouldn't have to pay the consequences of doing so, and it could just carry on getting worse and worse. So I'll come back to that in a minute, but because they were wrong about this, but I'll come back to it. So one of the key points was how you decide unfair prejudice, and that's quite difficult. And the High Court said this is quite a difficult point because at the end of the day, any moratorium where somebody doesn't have to pay a debt that they owe unfairly prejudices a creditor because they're not getting their money. So it has to be more than just the prejudice associated with not being paid that which you are owed. The test, though, has to be objective. So it's not just about the prejudice to this specific creditor. It's got to be looked at from an objective position, from the point of view of creditors more generally, and whether the fact that it happens to prejudice this creditor is probably less important than whether it prejudices creditors altogether. And it was argued that a balancing test had to be put between the creditor and the debtor, but the court said, well, yes, but not entirely, because it's impossible to balance a creditor with a debtor. Because at the end of the day, a debt moratorium means that a creditor is not being paid and a debtor is not having to pay. But if you get rid of the moratorium, then the debtor is going to have to pay the creditor. So it sort of flip-flops one way or the other. It's not very easy to balance that. So there's no aspect in which you can have the debtor pay a bit of what they owe. It's they either pay or they don't. The other point about it was post-moratorium conduct. So it was put before the court that conduct after the moratorium had come into effect might well be relevant. So, for example, if you had a mental health moratorium, but your mental health had started to improve, then it might well be the case that failing to then address your debts would be a reason to claim there was unfair prejudice. But in this case, it wasn't terribly helpful because the moratorium had been applied for, and then the claimant had sought to have it cancelled almost immediately. Within a week or so, they'd applied to the court, having been told no by the debt advisor. So there wasn't really a very helpful position in terms of looking at post-moratorium conduct because there hadn't really been any time to look at it. So the court was reluctant to make too many statements around this, but the point about it is that there is some degree of balance, but you have to be a bit careful. The other point the court made that was important was that if you cancel a moratorium, of course, you're not just dealing with the one creditor who's made the application. You expose the debtor to all of its creditors who might also come after it as well, and they may not all be prejudiced in the same way. Now, the reality is the court is empowered to make a limited order, partly lifting a moratorium, but in this case, the claimant had asked for a complete lift of the whole moratorium, total cancellation. So in practice, there was probably a bit of a mistake there, and they should probably have asked the court to exercise their power in a more limited manner and simply remove it in respect of certain debts. And the High Court was certainly dropping a hint there, in my view, that that the correct approach for most creditors would probably be to ask for a limited scope lifting of the moratoria. And you can see from a landlord's perspective, if there's a rent arrears claim that they're being barred from pursuing, the correct approach would be to ask the court to lift the moratorium with respect to the rent arrears claim without necessarily asking for the entire moratorium to be cancelled, which of course might affect debts to third parties that have got very little to do with the landlord. So the court was quite cool on the idea of just cancelling the whole thing and exposing a debtor to all of their creditors. The other thing was this issue of debt. So one of the complaints that the claimant Axnoller was making was the moratorium allowed the defendants to hide behind it while pursuing litigation, and the defendants were making that worse because they were saying that any new debt that was accrued during the moratoria was also shielded by the moratoria, so they could continue to pursue litigation, keep losing, keep incurring more and more cost orders, and they would never have to pay any of them. But actually, the court took a totally different view. And the court said, no. A moratoria is backwards looking only. It only applies to debts that are accrued before the moratoria comes into effect. It doesn't apply to new debts that are accrued once the moratoria starts. Now, the defendants were arguing it should, and their debt advisor appeared to think the same thing as well. So it's quite clear that debt advisors have been going around telling people that a moratorium will be continuing to protect them into the future after it's made. But one, the regulations don't read that way because they actually say that you have to pay your rent, for example. And indeed, the commentary from the government around it was quite clear that it didn't work that way. So there's very little good argument on this. And indeed, to some extent, the court also felt that was part of the balance. So while it was saying, well, yes, they'll be protected from their previous cost orders, that doesn't mean that new cost orders, if they continue to pursue questionable litigation, these defendants won't be protected from those because they don't fall into the moratoria. Now, the defendants did say, well, there's nothing to stop us having this moratoria cancelled and applying for a fresh one. If we've incurred new debts, we could just apply for a fresh moratoria that deals with all the new debts that comes into effect. But the High Court said, well, a moratoria has to be applied for in good faith, and it would be open to the court, by which it meant, again in High Court terms, that reading between the lines, that it would be bad faith for someone to simply cancel their moratorium and apply for a new one in order to throw in some more debt into it without some really good reasons. So if it was the case that a debt just they hadn't been aware of it, and they became alerted to it and it was problematic, that might be reason to cancel and restart. But what you can't do is willfully go out and acquire debt and get yourself into more debt, and then cancel your moratorium and have it remade in order to protect yourself from yet more debts you've willfully walked into during the first moratorium.
I suspect that most landlords will be concerned about ongoing rent. So I suppose this just confirms what you said previously, that the moratoria doesn't apply to the landlord's ongoing rent, which accrues after the order has been made.
Yeah, I mean, to some extent, that's sort of clear in the regulations anyway. But it was the High Court was making the point about all debts. So yeah, what you can't do with this is keep regenerating a fresh moratoria to keep lumping more and more debt into the party. It's meant to be a one-shot deal that protects you from a group of existing old school debts to allow you then to move forward and make a clean breast of things and sort things out. But it's not a mechanism to keep shielding yourself from yet more and more debt that you're running up. I mean, with the obvious point that the objective here is to move out of the situation. So yeah, it is quite good because it does confirm one of landlord's substantial concern that people could just keep making it worse. There was also a bit of an argument about bad faith. So the applicant was saying the whole moratorium had been applied for in bad faith because they had no intention of sorting their debt out. But this was just an assertion. It was evidence-free, though we had no proof of this whatsoever. So if you're going to make such an assertion, you're going to need some actual evidence, obviously. And to some extent, the applicant was a victim of their own actions here, because they charged into the moratorium. They basically had the moratorium through and just almost immediately applied for it to be set aside. And they hadn't, for example, sought to look for improvements in mental health, or indeed anything that would suggest that the moratorium was in bad faith. They just jumped to that conclusion and had a go. So, I mean, the point the High Court was making is you need to actually think it through and come up with some evidence. You can't just say, oh, this is bad faith because I don't like it. Now, what was interesting about it is that the debt advisor on a mental health moratorium is required to act on mental health evidence. Foolishly, really, the claimants hadn't demanded that be provided, which they should have done. And they didn't ask the court to make an order for it either, because their court was just ruling on the whole thing. They should perhaps have asked the court for an order for this and then had a hearing afterwards, but they didn't. The High Court did say, well, we don't know what the debt advisor was looking at, but there's a bit of a warning there to debt advisors that just because a mental health professional turns up and says, make a mental health breathing space, they shouldn't. What they're in fact required to do is look at the evidence from the mental health professional and satisfy themselves reasonably that it is appropriate to make a mental health breathing space. So the High Court sort of left this one open in this regard, because it did then order that that evidence should be handed over, and it sort of implied that the people could come back and make a further application if they felt that it was bad faith because the mental health evidence didn't support the making of a breathing space. So, as I said, evidence. Both sides had filed witness statements, and the court was quite clear that that was expected. So that's a point to note. The court didn't cross-examine anyone on their evidence, but it made clear that the court could. And so it's important to bear in mind, if you're going to make an application for a mental health breathing space, you could be cross-questioned on it later, or indeed any breathing space. The court was exceptionally critical of the mental health evidence. The applicant had no evidence in respect of mental health at all. And the defendants had a letter addressed to whom it may concern, which simply said, this person is in care for mental health, and I think it'd be a good idea to have a breathing space. But it didn't set out what the problem was, so what the particular diagnosis was, what the prognosis was, how long they expected it to last, why a mental health breathing space would help, what level of capacity this person had to deal with his debts, or indeed anything at all. So it was extremely generic. And while in the end the court said, well, it's not really for us to look too hard behind these breathing spaces because it's only a limited time thing, it was less than happy with the quality of the evidence that was supplied by the mental health professionals. So there is a bit of a sort of open position there that makes clear that mental health professionals need to come up with some proper evidence. And these sort of generic letters that you often see from doctors and things just aren't going to be good enough. So that's sort of the summary of the position. The High Court was reluctant to create too much precedent. It was quite conscious that it was the first one, and it was quite clear that it wasn't trying to create precedent. But I think the approach is interesting. It's quite clear that the High Court was trying to weigh the whole thing up. It was leaning towards the view that it wouldn't disturb a moratorium unless there was really good reason to do so. So it's definitely an uphill battle for someone who's trying to have one set aside. But it's also quite clear that litigation on debt moratoria is possible, albeit it's probably a minority sport and probably for the most egregious cases. So I'm happy to answer any questions. Obviously, there's a limited amount in terms of what I can say because I'm only talking about one case.
Okay, well, we haven't had any questions so far. So if you do have any questions, please pop them in the box fairly quickly. David, what would you say that the main messages are from this case, which landlords need to take account of?
Well, I think the first thing to bear in mind is that I think is useful is it's a debt moratorium is effectively a one-shot deal. It's historic debts, not future debts, and so it's very difficult to lump more into it. And I think the second point is that it is possible to have them set aside, but you're going to need to come up with some serious evidence. And I think the third point that's worth bearing in mind is that the court can do limited set aside, and that seems to be more productive than asking for the whole thing to be cancelled.
Mm-hmm. We've
There
had
is a question.
we've had a question in from Lee, who said, I have a Section 8 substantive hearing next week. Can the tenant get the hearing cancelled by applying for debt relief?
Yes, in theory, if they can get a debt advisor to make a moratorium, then the hearing would have to be adjourned. Yes, but they will have to get a debt advisor to get a moratorium. And the reality of the matter is, of course, that relatively few people are aware of these things, and so they haven't been. I mean, I've been. This is like the second one I'm aware of. I've heard of one being made so far from a contact, and I've seen this case. They're not exactly vast numbers of these things being made.
We've had another question. I have an old tenant who has a lot of arrears, and we agreed to a payment plan to help him pay this off, but he applied for a breathing space. Does that mean I'm not allowed to chase him for payments?
Well, it depends whether he got the breathing space. So if he was given a breathing space, then no, you cannot chase him because his debts now fall within that breathing space order. But it's only for 60 days and it's time limited.
What sort of criteria do the debt advisors take into account when applying for these? Because it has to go through a sort of regulated debt advisor, doesn't it? I mean, the tenant can't just do it without.
Yeah, I mean, they have to consider that it's reasonable, and they have to consider that there is a prospect of the tenant being able to enter into some suitable arrangement to clear their debts. I mean, whether that means negotiating some of them down or something else, but there has to. I mean, the objective of breathing space is to end up with it being terminated with a debt plan in place.
Mm-hmm. So if they're in such dire financial situations that there is absolutely no way that they'd be able to pay the debt off.
Well, you could enter a breathing space for that, but then you'd be moving relatively quickly to bankruptcy.
Mm-hmm.
It's not there to delay the inevitable.
Mm-hmm. So it's really for tenants who have large arrears and they're trying to sort out a plan to pay it off.
Yeah.
Okay, well that's sort of good news, really. So okay, well look, thank you very much for explaining the case and simplifying it for us, because it looked a bit of a nightmare when I looked into the reports. And thank you everybody for attending. This is being recorded and it will go up on the Landlord Law YouTube channel in due course. So thank you very much, David, and thank you everybody for attending.
Thanks.